I'd first like to thank our witnesses for joining us today to help examine gaps in existing federal records law and to discuss how lawmakers can ensure the National Archives and Record Administration, or NARA, can adequately maintain and preserve presidential and federal records. The federal government produces and receives an absolute enormous volume of documents and records every single day. These are essential to keeping an accurate account of what activities the government engages in, as well as ensuring that Americans, such as former service members, are able to get the benefits that they have so rightly earned. Accurate federal records are also critical to helping Congress hold the executive branch accountable, ensure appropriate use of taxpayer dollars, and make sure the federal government is working effectively for the American people. However, officials in previous administrations of both parties have failed to adhere to current federal record-keeping requirements and in some cases have blatantly disregarded them. Whether administrations avoided creating records of meetings, used personal emails and devices, disappearing message apps, or attempted to obscure their decision-making processes, these failures to appropriately handle presidential and federal records have limited the transparency for the American people and risk letting critical moments of our nation's history slip through the cracks. This has left the door wide open for historical misrepresentations and distortion. Most recently, we saw alarming reports that presidential records from the Trump administration were destroyed inside of the White House, and others were taken to the former president's private residence rather than being turned over to NARA. And although some of these records have been recovered, it's impossible for Congress to tell whether additional records have been destroyed or improperly handled, or if NARA has received all appropriate records from the administration. This lack of transparency and other challenges related to enforcing our existing federal records laws have made it difficult for NARA to ensure it is receiving all relevant presidential records. Other challenges include inadequate resources and technology, and the rapid proliferation of electronic records have also complicated NARA's responsibility to preserve these essential documents. For example, the National Personal Records Center within NARA, which is responsible for storing military personal records, faces a serious backlog of requests from veterans. This backlog, along with limited accessibility during the pandemic, has left veterans unable to obtain critical documents that help them access benefits they depend on each and every day. This is simply unacceptable and a key reason that Congress must urgently reform and modernize this process. Additionally, the outdated computer systems and outdated laws that regulate federal record keeping have also made the mishandling of sensitive and important documents more common. This can have serious consequences for government transparency and could conceal fraud, waste, and abuse from Congress as we work to provide oversight of the federal government. Despite these deficiencies, I remain confident that this is a body that can work together on a bipartisan basis, and we can work to improve the federal record-keeping process. I am currently working on legislation that will increase visibility, it'll strengthen existing laws, update regulations, and modernize this process by using emerging technologies so that we can ensure that NARA can adequately preserve and provide appropriate access to both federal and all federal records. As we mark the 17th annual Sunshine Week, a nationwide initiative dedicated to educating the public about the importance of transparency in government, I look forward to discussing how Congress can further strengthen federal records processes and improve the transparencies for all Americans. Today, I'm grateful to welcome a panel of experts who can discuss our federal records management in much greater detail, help us identify gaps in the law as well as its implementation, and broadly discuss what actions Congress can take to better protect the public records. So thank you again for being here. We look forward to a robust discussion. Ranking Member Portman, you are now recognized for your opening comments.
Thank you, Mr. Chairman, and thanks to our witnesses for being here. Transparency in government is obviously a pillar of our democracy and something we should all ensure continues into the digital age because it's harder and harder in some respects, as we'll talk about today. It's an area I've worked on a lot. I've sponsored the Data Act, the Access to Congressionally Mandated Reports Act, the Open Courts Act, the Regulatory Accountability Act, and a lot of others. In fact, when I was at the Office of Management and Budget, I put all earmarks online, which had an interesting effect in terms of transparency. But in order to have that transparency and accountability, we obviously need a record of what government's doing day in and day out, what government's doing right, what government's doing wrong. That way citizens can learn and hold their government and officials accountable. Having a fulsome record of government activity is also important to the future. It's important to historians. It's important to media. It's important to citizens to have that. Think tanks can play an important role only if they have access to information, as an example. So it's good we're having this hearing today on how to look at the Presidential Records Act and the Federal Records Act. It's a bipartisan issue, by the way. I can see from the prepared comments that some of our witnesses will reference our previous presidential controversies, but will note, as I do, that administrations of both parties have had records-related issues, and lack of clarity has caused some of that. As a member of this committee back in 2014, I worked on the 2014 amendments to the Presidential Records Act and Federal Records Act. Among other things, we tried to streamline the process for making presidential records available to the public after they go to the National Archives. We prohibited the use of non-official electronic messaging accounts by covered workers unless they copy or forward communications to official accounts, clarified the definition of government records so that it covers them regardless of what format they're in, and provided an enforcement scheme for violations. So just in 2014, we went through this and made a number of amendments. But the world's actually changed quite a bit since 2014. Records have become much more digitized. There are now apps that make messages disappear. There's also technology that automatically categorizes documents. So I agree that we as a committee should look into these and other changes and see how the law might need to be updated to account for changes since 2014. And I'm glad these three witnesses are with us today to help us do just that. I see they've all spent time dealing with records-related issues, so I want to thank them in advance for testifying, and I look forward to hearing what they have to say and engaging in a good dialogue about these issues. Thank you, Mr. Chairman.
Thank you, Senator Portman. It's the practice of the Homeland Security and Government Affairs Committee to swear in witnesses, so if each of you would please stand and raise your right hand. Do you swear the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Our first witness is Jason Barron. Mr. Barron serves as the professor of the practice at the University of Maryland's College of Information Studies, or iSchool, where he taught the first graduate-level seminar on e-discovery, a form of digital investigation here in the United States. Mr. Barron brings 33 years of experience in public service, including 13 years as the first appointed director of litigation at NARA, and previously served as a trial attorney and senior counsel at the U.S. Department of Justice. Mr. Barron regularly writes and speaks on subjects involving preservation of and access to electronic records, and he has also served as co-chair of the Working Group on Electronic Document Retention and Production at the Sedona Conference. Mr. Barron, welcome to the committee. You may proceed with your opening comments.
Thank you. Chairman Peters, Ranking Member Portman, members of the committee, thank you for the opportunity to testify here today regarding amending the Presidential and Federal Records Acts. As the Senator mentioned, during a 33-year career in federal service, I saw firsthand the introduction of new communications technologies that have transformed the way federal employees create records. Based on my experience in government and after, I believe that further amendments to the PRA and the FRA are needed to keep up with recent changes in technology. As a recent GAO report stated, quote, records are the foundation of open government, supporting the principles of transparency, participation, and collaboration, unquote. One form of communications technology now poses what I see is an existential threat to government record keeping, namely forms of ephemeral messaging which self-destruct after messages are sent. Such messages, when used by officials on matters relating to government business, simply vanish from history. As the committee is well aware, there have been numerous instances of attention-grabbing headlines involving the use of WhatsApp, Wicker, Confide, and Signal by White House staff and other federal officials. The popularity of these forms of messaging apps effectively means that anyone in the federal government can communicate in ways that amount to an end run around the records laws that otherwise require adequate documentation of government business. I believe federal employees, including in both the White House and throughout the executive branch, should be prohibited from using non-preservable electronic messaging apps to transact government business. However, employees should still be able to use messaging apps that are authorized for use by the White House or by each agency, provided those messages are captured in an official record-keeping system. Beyond that gap in current law, I believe we are at an inflection point in the history of government record-keeping. Starting with the Reagan administration and going through the Trump administration, NARA now holds an estimated 600 million emails, representing 3 billion pages. Can the American people get access to most of those records? Well, theoretically, yes, but as a practical matter, less than 0.1% of these records have been opened. Pursuant to policies put into effect in 2019, starting on December 31st, 2022, the end of this year, NARA will no longer take in newly created paper records. All this means NARA should expect to receive literally billions of electronic records over the coming decades, a huge challenge that calls for new advanced search technologies to provide access to the American people. Looming perhaps even larger, by the same end of 2022 date, all federal agencies will be required to preserve both their temporary and permanent records in electronic form. Without employing advanced search technologies and advanced analytics, agencies are going to be under an increasingly huge burden in categorizing their records, disposing of their records in accordance with record schedules, and providing access to those records to Congress and to the American people. For these reasons, I support 2 further policy initiatives to be codified in current law that will assist in record keeping given the new reality. First, I believe the current voluntary policy known as Capstone for the archiving of senior official emails should be codified in statute, not only to ensure that all agencies preserve these records, but that electronic messaging, including ephemeral apps, also be captured for permanent preservation. Second, I believe the government can learn from industry and academia how machine learning and advanced data analytics are used in the private sector to manage, categorize, search, and provide access to electronic records. That is why I believe a high-level advisory committee consisting of subject matter experts would be helpful in jump-starting records management and records access throughout the government. New forms of communications technology have led us to this moment, and new forms of advanced artificial intelligence software can help address the profound records management challenges the government faces. Thank you, and I look forward to the discussion here today.
Thank you, Mr. Barron. Our next witness is Ann Weismann. Ms. Weismann is a public interest lawyer and the former chief counsel and chief FOIA counsel at Citizens for Responsibility and Ethics in Washington, a nonprofit organization committed to deterring unethical government conduct. Ms. Weismann has handled a wide range of high-profile litigation lawsuits which sought public access to White House visitor records and the recovery and restoration of millions of missing White House emails. Previously, Ms. Weismann has served as an assistant branch director at the Department of Justice, where she oversaw the department's government information litigation. Ms. Weismann, welcome to the committee. You may proceed with your opening comments.
Thank you. Chairman Peters, Ranking Member Portman, and members of the committee, thank you for the opportunity to testify today about needed reforms to the Presidential Records Act and the Federal Records Act. I'm testifying on my own behalf. I have spent many years seeking to enforce these statutes through litigation to ensure the preservation of our nation's history and the accountability that comes from public access to government information. In that capacity, I have experienced the frustrating limitations of these laws. Today, I highlight some proposed reforms to address those limitations and ensure the statute's continued vitality in a digital age. Both the PRA and the FRA fall short in two significant respects. First, neither contains sufficiently effective enforcement mechanisms, which has placed the preservation of our historical record at considerable risk. Second, as products of an era when the government operated exclusively in paper, neither has kept pace with changing technologies. Recent events highlight these problems, but their origins date back decades, accelerated by the transition to a digital environment. In my written testimony, I outlined the disturbing and ongoing trend of administrations from both political parties of ignoring or outright flouting their record-keeping responsibilities. This is a bipartisan problem that demands a bipartisan solution. I also testified in my written testimony about my unsuccessful attempts through litigation to redress these record-keeping violations. In each case, the judicial system provided no relief, believing it lacked any authority to enforce the terms of the PRA. Why did Congress enact such a toothless law? It assumed presidents would voluntarily comply, both because they would surely recognize the rule of law that is so fundamental to our democracy, and because they would want to preserve their place in history through a full historical record. We now have reason to question the efficacy of the norm-based system that underlies the PRA. It is therefore up to Congress to transform the PRA to a statute that achieves its intended purpose, preserving our history. As a first step, Congress should establish a bright-line rule that all presidential records, given their inherent value, merit preservation by eliminating the disposal provision of the PRA. Congress should require the White House counsel to certify to the archivist on a quarterly basis those PRA-covered employees who are in compliance with the law. Certification affords a level of accountability and transparency currently absent in the statute. Congress should require the Office of Administration to report to Congress and the archivist at least annually on EOP's implementation of the record-keeping laws. This can serve as an early warning system to avoid learning of record-keeping violations after an administration has left office and remediation may not be possible. The PRA should impose a mandatory reporting requirement on the White House counsel to advise the archivist and the Attorney General about the threatened or actual destruction of a record or systemic problems, and should charge the White House counsel with fixing those problems. Congress should require the White House counsel to share with the archivist at the beginning of a new administration record-keeping guidance for the Executive Office of the President to be posted on NARA's website. And finally, Congress should conform the PRA with the technical realities of the 21st century by prohibiting the use of any technology that does not enable the preservation of records created by that technology. And I'll refer to my written testimony for needed reforms to the Federal Records Act. But let me close with this. The PRA and the FRA rest on the central proposition that government records, as the records of the people, play an essential role in creating a stronger democracy. But both statutes have proven to be no match for the advances of technology and individuals intent on operating in secrecy and without accountability. The recent revelations raise a concern that this important issue will be dismissed as nothing more than partisan politics in Washington. I hope this is not the case. Absent a legislative fix, the gap in our historical record will continue to widen, and government officials, including those at the highest levels, will feel empowered to ignore their record-keeping obligations at will. I look forward to working with the committee on this issue. Thank you.
Well, thank you, Ms. Weismann. Our final witness is Jonathan Turley. Mr. Turley is Professor of Public Interest Law at the George Washington University Law School and is a nationally recognized legal scholar who has written extensively in areas ranging from constitutional law to legal theory to tort law. Professor Turley is also a recognized legal commentator whose articles on legal and policy issues regularly appear in national newspapers. President Turley has also served as counsel in a variety of national security and terrorism cases. Professor, welcome to the committee. We look forward to hearing your testimony.
Thank you, Chairman Peters, Ranking Member Portman, members of the Homeland Security and Governmental Affairs Committee. It's a great honor to appear before you to talk about efforts to reform federal and presidential record management. 20 years ago, I testified on the Presidential Records Act and the need, even then, to create reforms to protect and preserve the records of our country. The FRA and PRA were transformative laws that guaranteed not only greater transparency but accountability for the actions taken in the name of the public. It is said that those who cannot remember the past are condemned to repeat it. These laws are meant to stop that from being a reality for this republic. While I'm happy to discuss other proposals, my written testimony talks about 6 areas of possible reforms. There is great overlap with my colleagues on the panel, and I'm greatly honored to appear with them, particularly Ann Weismann, who is one of the graduates of George Washington Law School, one of our more esteemed graduates, and I also commend the committee for guaranteeing that any panel should have a majority of people connected to George Washington Law School. The first area that I address is addressing new technology that's been discussed already by some of our panel. The Congress has attempted to deal with that with the Presidential and Federal Records Act, and more importantly, the Electronic Message Preservation Act. But ambiguities still exist, and those ambiguities exacerbate the erosion of these standards in the face of new social media technology. That technology is now dominant as a form of communication with 3 billion social media users. And so officials in government, like all citizens, move casually between platforms, and that creates much of the problems that we are seeing. One of the problems that I focus on, as do some of my colleagues, is the use of message deleting technology, Telegram, WhatsApp, Wicker, and Confide, those types of platforms that immediately destroy messaging. One of the things I suggest is that the use of these apps should be treated as a disposal decision. Since they automatically dispose of these messages, they should be banned unless the apps are modified, as noted by Jason. I also address deterring the use of unofficial accounts, and mandating agency adoption of capstone policies, another issue that Jason has taken a lead in. I don't understand why we do not make the capstone policies a mandatory obligation on agencies. I've never heard an explanation why we don't codify that standard. I also suggest, and this is consistent with Ann's testimony, the elimination of disposal discretion in presidents. Again, I've never seen a particularly compelling argument in today's digitized age for leaving that authority under 2203 CE with the White House. Perhaps one could be made, but I have not seen it. It seems to me that given the thrust of our laws, the archivist is in an excellent position to make those types of decisions. It is often the case that you don't realize the importance of a record until many years later. And it just seems odd to me that we give that discretion under Section 2203. I also commend the effort to create certifications, regular, whether annual or quarterly. The importance of that is that it reminds officials to be cautious and careful. I also commend the use of citizen lawsuits, although I do have some concerns with the citizen lawsuit provision in the law. It seems to me that we have to have a better idea of the standard and basis for those types of actions to avoid constitutional problems. Finally, while the first 5 proposals effectively cut against the executive branch. The sixth one suggests the possibility of accommodating the executive branch. I think that the basis for overriding President Trump's privilege assertions was warranted. It was certainly lawful. The question is whether we want in the future to have a more clear standard and the possibility of a bicameral solution to overriding presidents in those first critical years after they leave office. I suggest among those standards the one used under SHIELD laws to establish a need that cannot be accomplished elsewhere. I will end as a Madisonian scholar that I will note that tomorrow is James Madison's birthday. He would be 271, and if he were alive today, we'd all be better for it. But I will also note, as is often talked about with his quote, that popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy. He was actually referring to public education, not public access to information. But if you read him more closely, what he's really talking about is an educated and informed public. And therefore, I have no reservations to appropriate his quote and to say that these laws and these reforms can help us avoid both that farce and that tragedy. Thank you very much.
Thank you, Mr. Turley. My first question is going to be to all of you. I'll start with Mr. Barron, then we'll work down the table there. In all of your testimony, you've highlighted a number of challenges that we have with both presidential and federal management records. I want to try to bring this down to what you think is the most important challenges, each of you, of the number of things that you've said. If you were going to give me one or two most important, Mr. Barron, what would that be?
Well, I think record keeping is all about accountability. The American people deserve to know what their government is up to. And the way to do that in 2022 is to update the law to take into account there are so many new technologies that are out there, both ones that are the government is struggling to deal with in terms of like ephemeral communications, but also there are technologies that can help the government in meeting its challenges. And so we want to talk about that in terms of managing access records, including with artificial intelligence and machine learning.
Right. Ms. Weismann?
I think the lack of an effective and robust enforcement scheme in both statutes is a problem. I mean, I've outlined in my written testimony how we can beef up the enforcement system in the FRA, which I think is really called for because the enforcement scheme as it currently exists really is responding to operating in a paper world, and we don't anymore. And with the PRA, I agree with Professor Turley that there are potential constitutional problems, but I don't think we have to go that far, and that's why I place the emphasis and think it needs to be placed on building in certain guardrails, whether it's annual or quarterly reporting requirements, making sure that Congress and the archivists are up to date about what is going on in the White House, so we don't have a situation that after a president leaves office, we find that, in fact, there were systemic violations and records may have been lost.
Thank you, Ms. Weismann. Mr. Turley.
Thank you, Mr. Chairman. I guess I would rank them as, first and foremost, dealing with ephemeral messaging systems. It seems to me that that has to be a priority. It should be barred. Absent a modified system that allows the recording of those messaging. And the simple approach is that the use of those types of apps should be viewed as a destruction decision, a disposal decision in contravention of the federal law. Second, I would like to see the capstone system codified. I don't see why it's not. I really have one of those things where I looked at it to see I must be missing something. But NARA has pushed for many years for capstone to be adopted by agencies. And then finally, I do think that this committee should consider the recent controversy with the override of President Trump's privilege assertions, not because that was the wrong decision. But I am a little worried about overrides in the future from President Biden on. Politics has become incredibly bitter and divided today. It seems to me that there could be an accommodation by Congress to make sure that we have a bicameral approach or to have a more detailed standard that pushes committees to find material by other sources before they take this critical step.
Well, thank you. I'm going to ask all of you again, and this time I'll start with Professor Turley and work the other way in fairness. I think all of you have seen draft language of legislation that I'm working on to deal with this situation, and Professor Turley, I think you referenced it in your testimony as well. So I'd just like to go down the panel. What are your thoughts on that legislation? Does it address some of these key issues? Just generally, what do you think about the draft as you've seen it so far? Professor Turley.
I think it's an excellent platform to address many of the issues that we've been talking about. The one area that I, quite frankly, am a little bit concerned with is the citizen lawsuit provisions, the private cause of action. I am a huge advocate of what are called private attorneys general provisions. It's just that I'm a little bit uncertain as to the standard and how that would be used. As you know, researchers and historians have sued in the past and successfully have brought actions. So I like the idea of empowering that further. It's just that we have to be a little bit careful with the Nixon case as to how far that would go without triggering a separation of powers fight and the other constitutional concerns.
The other aspect, the other parts of the legislation you support?
Well, I really like the certification requirements, particularly in some ways because it reminds officials not to use these unofficial platforms and devices. I think there are two groups of officials we're dealing with, the sort of clueless and the conspiratorial, right? A lot of people are just clueless. They move so casually between devices, you can forget. And certification sort of is a shot across the bow to saying, this is not allowed. It also is a formal federal statement that could be used against you if you say something false.
Right. Thank you. Ms. Weismann, your thoughts?
I think it is an excellent start, and actually more than a start. I think I really applaud how comprehensive it is. I think that it is really dealing with the major issues that we have seen and we've commented on. So I support it wholeheartedly.
Right. Thank you. Mr. Barron.
I support the provisions that I've seen. In particular, though, I think the bill addresses the fact that ephemeral messaging apps should be prohibited except when they are captured or archived in what I would hope to be in the same place that the Capstone email repositories are. So I like that a lot. I like the codification of Capstone being statutory and mandatory instead of voluntary. And from my written testimony, you know that I am a big advocate of new ways of dealing with search and with providing access to the American people. And the only way to do that is what the bill suggests is that have experts talk to the government. The government can learn from academia and industry about artificial intelligence, machine learning, and other analytics. So I'm a big proponent of that for the government.
Thank you, Mr. Brown. Ranking Member Portman, you're recognized for your questions.
Great. Thanks, Chairman. Thank you to the witnesses. We talked about ambiguity a little, and earlier I mentioned that no clarification is needed. And Professor Turley, you talked to how ambiguity can lead to problems. I think complexity can too, which is part of ambiguity, I suppose, but specifically keeping it as simple as possible. I was Associate Counsel to the President under President George H.W. Bush, the first Bush, and one of my jobs was to try to help interpret the rules at the time, which were actually far different than they are now. And then I served in the second Bush administration as well, and including at the Office of Management and Budget, so I had the same sort of issues with some of my team, which is just confusion about what the rules are. And you know, people come in and out of the executive branch, particularly at the White House, with some frequency. So maybe in some of the agencies people stay longer, but and a lot of them are younger, and a lot of them really don't have an intuitive sense of what this is about because it doesn't make sense given their private lives and their work lives, where they're free to be able to destroy records that might be sensitive or even embarrassing. So what do you all think about that? And maybe start with you, Professor Turley, since you talked about ambiguity, and I would add complexity there as an issue. And you talked about the Capstone system as an example, which is not mandated. And that's confusing to people, I think. So what are your thoughts on that?
Well, Senator Portman, I think that your concern is more than justified in the sense that real people have to use these rules. And you don't want rules that only the White House counsel and his experts understand. You need rules that your average official sitting there knows where that line is. And in what may be one of the most unique hearings of my life, this actually would simplify things. Usually things get more complex around here. But we would simplify it in a couple of ways. One is by codifying Capstone, you'd have a consistent approach across the agencies, and it actually takes away a lot of decisions. It just goes ahead and preserves records. By getting rid of the disposal authority in the White House, I don't really think the White House loses much. I've never understood why it was so necessary to have that instead of just preserving it, leaving it for the archives. And then banning ephemeral systems, once again, creates a bright line rule. As do these regular certifications. So in those terms, I think this does create bright lines and actually simplifies things, because I readily agree with you that the only way that we will be able to successfully accomplish this mission is for people to understand where those lines are.
Yeah, now, the other part of this is, and I understand we're working on some legislation here to try to create brighter lines, but if the bright lines don't make sense to people, in other words, if it seems counterintuitive, that's an issue as well. And so personal communication as an example, how do you delineate that? And then this broader issue that maybe all the panel can talk about, which is really the balance of preserving records and the value of public disclosure, which we talked about, and the importance of confidentiality of certain sensitive, particularly presidential communications. Where is that line? Maybe Mr. Barron and Ms. Weismann, you could talk about that.
Thank you, Senator. I do want to say that your point about confusion is well taken, but there's a larger issue about compliance in the government. And one of the reasons that Capstone is so successful, even though voluntary, on the part of about 200 federal agencies, is because it automates the process. It takes the burden away from people so that the system, the computer system, can basically take senior level officials' emails and put them into an archive without anybody having to manually do anything. So that's that point. The rules of confidentiality, well, in one sense, it's very important at the White House for every record is going to be permanently preserved. And so FOIA doesn't apply, but FOIA does apply 5 years after a president leaves office, and so subject to restrictions. And so records are confidential in some sense, but they need to be made. They need to be created, and if ephemeral communications are essentially acting as an end run around normal record keeping at the White House or in the executive branch, those records will not be preserved.
Yeah, and by ephemeral, you mean using the apps that destroy the message after it's sent.
That's right.
A certain period of time. Yeah, Ms. Weismann.
On the issue of confidentiality, we have a rich history and tradition of protecting that through the assertion of executive privilege. And in this respect, I respectfully disagree with Professor Turley. I think the recent example with the assertion by former President Trump and the refusal of President Biden to recognize that assertion illustrates exactly that we have the right processes in place. President Trump had the ability to fully explain his position and assert his interests in several courts, as did the president, and several courts weighed those assertions and made a decision. And they did so based on, I think a pretty well-developed body of case law. Privilege claims are really the bread and butter of what courts do. So I think there are definitely protections already in place to ensure confidentiality. The PRA itself has those protections in place by providing for confidentiality for a set number of years. But we also now know that there are processes that a former president can use in order to protect interests that they believe need to be protected. So I am of the view that there are adequate protections already in the judicial system that we have.
Professor Turley, response to that?
I would respectfully disagree, and I don't think we're that far apart. I mean, I think we share many of the same values with regard to these laws, and I think we share the same conclusion as to this particular controversy. What I was suggesting in my testimony is that there is an ambiguity here. I don't agree that the standard is so clear for presidents, and when they go to court, that they can really address the full scope of the concerns here. If you procedurally are correct in the use of this act, the only thing that really a court can balance is the type of Nixon criteria as to separation of powers, and that's a standard that is largely still favoring disclosure in many of these cases. All I'm suggesting is that Congress can consider, in addition to these other proposals that cut back on the executive branch, it can consider articulating a clear standard. And it seems to me the standard on the SHIELD laws fits sort of nicely with these issues. That, you know, if you take, for example, the Trump controversy on the override, I expect you could have gotten a bicameral vote to get access. But putting that aside, the standard itself is simply suggesting that if you can get this information from another source, as we do under SHIELD laws, that should be the first course that you take. Because I think there is room for mischief in the future. And I am worried because if we see the terrible divisions in our politics today, I'm worried about President Biden and other successors in being able to feel confident that their communications will be confidential, particularly for that period immediately after they leave office.
Yeah, I think it's a good point. My time's expired, but if you all could make sure all three of you give us your specific views on the private right of action issue and whether there's a necessary standard and basis that you would think be necessary in order for people to be able to pursue a private right of action. I have concerns about that, but I just want to hear from each of you. If you could provide your written comments on that for the record, that'd be great. Thank you, Mr. Chairman.
Thank you, Ranking Member Portman. Senator Carper, you're recognized for your questions.
Thanks. Thanks so much, Mr. Chairman. And to our witnesses, good morning, and thank you all for joining us today. I have three questions. I'm going to try to get to. One of those deals with the importance of federal records management for accountability and transparency. The second one deals with how the Presidential and Federal Records Act amendments of 2014 helped to improve transparency across the executive branch and the gaps that still remain. The third question will focus on improving NARA's role in records management through enhanced support. Start off for each of our three witnesses on the importance of federal records management for accountability and transparency. Ms. Weismann, Professor Barron, and Mr. Turley. I was fortunate to serve as chairman of this committee in 2014. Our ranking member was Tom Coburn from Oklahoma, and he and I took on a very important issue of modernizing the presidential and federal records to try to capture and archive electronic records, among other things. The legislation was bipartisan and I'm proud to say it was bicameral. Because we all recognize that as public servants, our duty was to provide transparency and to deliver results to the American people for whom we work. Ms. Weismann, followed by Professor Barron and Mr. Turley. For some, the issue of federal record reform can be pretty dry or even boring at first glance. But briefly, can you provide more context as to why every American should pay attention to this conversation? Why is this important?
It's important because this is our history. These records tell the story, our story as a nation. We can't possibly understand how to chart a course forward if we don't understand what happened in the past. They're also important for accountability. This committee and other committees depend on the availability of records that talk about that explain what happened and why it happened. It's important for public accountability. Laws like the Freedom of Information Act would have no utility whatsoever if there were no records. Journalists would not be able to do their job if there were no records. So, information is really the cornerstone of our democracy, and that's why it's so critical that this committee act to take steps to ensure that records are preserved.
Okay, great. Thanks so much. Professor Barron, the same question, if you would, please. Why is this important to the Americans?
Thank you, Senator. Well, we're talking today about the Presidential Records Act and the Federal Records Act. And the PRA, when it was enacted in 1978, it made clear that the president's records, the records of the White House, are not owned by a president. They're owned by the American people. So that's the first point about accountability. And second, with the Federal Records Act, ever since 1950, there's been a requirement that every agency in government adequately document its activities. Ms. Weismann is exactly right. You have to create records and manage the records, preserve the records, so that you can provide access to the American people of those records, and the Freedom of Information Act has been with us since 1966. The problem in 2022 is that we're literally talking about billions of records in electronic form, something that agencies have not dealt with, and the National Archives has not dealt with on that scale. And so it's a very timely hearing here to be able to discuss what to do to move forward in the next decade so that we can continue to have accountability for the American people.
Good. Thank you, Mr. Barron. Mr. Turley, please.
Oh, thank you,
Welcome.
Senator. There's, as usual, much agreement between the three of us. Notably, outside of the National Archives is a statute that says the past is prologue, and that is the premise of much of these laws, that we will repeat the errors of the past if we don't understand them, and we won't understand them unless we preserve the record of what has been done in the public's name. And that's the reason I think all three of us share a natural default for preservation and a faith in the archives to make proper decisions. But I also wanted to note that as we look at how these things work interstitially between these laws, there are significant differences, surprisingly so, between the FRA and the PRA on issues like disposal policies that we can simplify. And I agree with Mr. Barron that by some of the things that all three of us are supporting here would actually bring greater clarity and, to Senator Portman's view, greater simplicity in how we deal with these issues. And I am a huge advocate for simplifying these rules so that people understand them.
Okay, great. Thank you. My second question would be for Ms. Weismann and for Professor Barron. Senator Coburn and former Senator Coburn and I set out to reform the Presidential and Federal Records Act, 8 years ago, to establish a clearer process by which incumbent and former presidents could review presidential records prior to their release and to improve the federal government's ability to capture and archive electronic records. What are some lessons learned from these reform efforts for federal and presidential record keeping? And what did Congress miss that we should prioritize addressing now? Two questions. What are some lessons learned from these reform efforts for federal and presidential record keeping? And second, what did Congress miss that we should prioritize addressing now? That would be for Ms. Weismann and Professor Barron. Ms. Weismann, go ahead.
I think one of the lessons learned is the need to keep pace with technology. Technology, as Jason Barron has been emphasizing, is both our savior and could eventually be the downfall of us all. We just can't keep pace with it. And so I think the statutes the amendments that Congress has already made have been an important first step, but they're a first step only. We need to deal in a more comprehensive and decisive way, especially with ephemeral messages.
Thank you. And Professor Barron, same question, please.
So I think the 2014 amendments did some important things. It modernized the definition of a federal record in acknowledging expressly digital or electronic records were part of the world of record keeping. But the lesson learned, I think, especially on the provisions related to non-official accounts and using them, is that there's a very difficult problem with compliance in government. If you leave to individuals to copy or forward their electronic messages. They're very busy. You all understand that. Not everybody can copy or forward 100 messages a day. That is why I've been advocating for a long time that we automate the process. And so between 2014 and 2022, because of compliance concerns, I think it's time to spend a moment here to talk about automation of record keeping and moving forward in that way.
All right, thank you very, very much. And I have a third question. My time has expired, Mr. Chairman. I just want to mention my third question for the record. But what does the National Archive and Records Administration require to ensure that agencies can fulfill its mission, and an agency can fulfill its mission, particularly in the digital age? And I'll ask that one for the record. Again, our thanks to all of you for being with us today and taking up and helping us take up an issue that was important 8 years ago when Senator Coburn and I led the effort on this, and it's important still today. Thank you very much.
Thank you, Senator Carper. Senator Langford, you're recognized for your
Chairman, thank you. Thanks to all of our witnesses in this conversation. Let me get the human side of this as well. Because the more you pull on people to say you've got to give us every scrap of every piece, the more you incentivize people to work off the record because they want to have private conversations. These are human beings as well. Regardless of the administration, the perspective, every administration is looking for a way that we can actually just talk to each other without having to have everything that we have get pulled into this record. Whether it's Hillary Clinton and her private server, whether it's others that are trying to be able to pull in to be able to say, I've got to find some way to be able to have off-the-record conversations for things, or what it was Gmail originally with multiple administrations now, or was now messaging apps to be able to make messages disappear. My question to you is a larger, broader question. How do we process through a private conversation, that is a purely private conversation between two peers or two individuals, or even the president and his staff, that's a private conversation and a public conversation? Or would you define it as you're the president, you're on the president's staff, everything you have should be actually gathered, you have no such thing as a private life? Ms. Weismann, you want to start with that? Mr. Turley, you want to jump in?
Yes, well, the Presidential Records Act itself defines presidential record very broadly. And essentially, you're correct. The president has no private life. That is, as long as the president is acting in an official, constitutional, or ceremonial capacity, the records that are generated must be preserved. Now, I think the degree to which a president or an agency official can have a private conversation or keep certain records confidential is a separate issue that should be kept separate from the issue of preservation. Because if you don't even have preservation, issues about potential privileges fall out altogether. But I think the Presidential Records Act, at its heart, recognizes that because someone is the president, everything they do and say is relevant and important and needs to be preserved unless they are acting in a purely personal capacity, a letter to a grandchild, for example, or in a purely political way. They're head of their political party. Those records are not preserved under the PRA, but otherwise it's all fair game.
Right. Ms. Turley, my question just is this defined overly broad? It actually encourages people to be able to push outside the box.
Well, it is exceptionally broad. It was designed to be broad, to have the natural default towards preservation. But I think your point is well taken, and more importantly, the Supreme Court views your point is well taken. I mean, the Supreme Court has repeatedly said that there is a danger when you chill communications in the White House. This isn't for personal stuff. This is just on official material, that you can have a chilling effect on people being willing to be open about issues. When it comes to personal matters, my colleague is correct that technically on a purely personal matter, it is not an official record, but because you are President of the United States, there's very few things that people consider to be entirely personal. The real gatekeeper there for the White House is, in fact, the White House counsel and the archivist who can help sort of delineate those lines to create some breathing space. I do think that it's important not to discount this. That is, yeah, presidents are political animals, but living in a fishbowl on every level of your life is not healthy. And this goes back to what Senator Portman was talking about as well, that is, we have to try at least to create these bright line line rules. But I think the key role here is with the White House counsel and the archivist to make that as clear as possible of what subjects can be done without that falling under the PRA.
Right. Well, the clearest example of that is Congress doesn't live under that same rule. None of us here have the rule that we have no document, no scrap of paper, no anything that we have that has to be that can be destroyed, has to be preserved. Congress gets to choose what they're doing as far as what's private and what's public on that. That doesn't seem to be so with the executive branch. And what I'm trying to figure out is how do we create a system where we're incentivizing the preservation of records because people want to know, they want to study it, they want to look back on history. All of us are still upset with Martha Washington for burning every one of those papers 250 years ago. We get that. But there is a whole series of things that are also dealing with the humanity of people that we also have to acknowledge on this and try to figure out how to be able to create a system where we're incentivizing keeping records rather than incentivizing actually trying to be able to work outside the system on it long term. We have a challenge here with Congress as well in trying to be able to get documents from agencies, period, on this. For some reason of late, it's faster to FOIA a record than it is for Congress to actually request a record. That's become a very significant issue where administrations are saying, yes, we have those records, but we're not going to turn those over. But if there's a FOIA record, amazingly of late, the records get turned over to Congress the same day the FOIA is released to an outside entity. That's a separate issue that we've got to be able to determine what happens. I've seen this even in a request that we made. Agencies are creating a new standard for religious accommodation for the vaccines. Well, this has not existed in agencies before, and so they released out on the Federal Register that we're going to keep track of people that work in the federal government, what their religious preference is, and we're going to store that in our records. We're going to request that from individuals and store it in our records. Suddenly now we have a record now that I would assume would be FOIAble at some point or would become a permanent part of record that people could actually get access to that has personal information on their religious preferences that gets into the mix of this. So that's a different issue on records, but it becomes a pretty significant issue. Professor Turley, you have a comment on that?
No, I think that's absolutely true. I mean, I have another default as a Madisonian scholar, and that is I tend to favor Congress in fights like this. And I totally agree with you that there continues to be a lack of responsiveness, and this is not a Republican or Democratic issue. I don't know how many times I've testified about this. Congress can do more to be aggressive in forcing disclosures. When they have gone to court, they have largely prevailed on asserting their right to information. And I do think that's something we have to look at very closely. I also want to note something else. When you raise the fact that these laws can give sort of perverse incentive for people to go offline, that is well documented. We have previous administrations where officials admitted that they were meeting at Starbucks and finding ways to avoid creating paper records. And so your concern is well founded, I think, in history.
Sharon, thank you.
Thank you, Senator Langford. Mr. Barron, as you mentioned in your testimony, after 2022, NARA is going to no longer accept executive branch records in paper form. Could you explain to this committee the magnitude of this policy change and the challenges it's going to pose to NARA and, quite frankly, the rest of the executive branch?
Senator, it's transformative. The fact that NARA will no longer take paper, but only digital or electronic records means that over the course of this decade and beyond, there will be tremendous amounts of records, I've said billions, that are coming. And I'm afraid that because of personal information in those records, it's going to be very difficult to use current processes for the American people to get access to them. And so that's a very, very big challenge. But the 2022 mandate from the archivists and OMB also means that after this year, every executive branch agency is also going electronic. They're transitioning so that all of their records are being managed electronically, and that means that they need to categorize them in a certain way, and they need to dispose of them, and they need to search them for FOIA purposes. And all of that is very difficult if you have tremendous amounts of electronic records that are there. We already see that in capstone repositories, which I support wholeheartedly because it's an archive of emails that otherwise would never have been printed out and saved in government files. But so we have to orient ourselves. We have to reimagine federal record keeping to deal with these volumes that are coming.
Well, and you talked about in some of your previous testimony about technological advancements and resources. Could you tell us more exactly what we're going to need to do and what sort of resources may be necessary to be able to get a handle around these documents?
Senator, as I stated in my written testimony, I've been a lawyer involved in e-discovery, electronic discovery, for the last couple of decades. And the legal community knows what state-of-the-art machine learning can do for finding responsive documents and filtering them for privilege. And so there seems to be a gap. There's the private sector that has some experience now with really state-of-the-art artificial intelligence, and not so much in government. There are some agencies that know about these tools from a litigator's perspective, but no one in the FOIA community and no one in the records management community are using machine learning for records management purposes, or if they do, they're very small numbers throughout the government. And so we really need to have a conversation and have experts lead that conversation so that record keeping can deal with these large volumes of records. And there are ways, there are tools that I know well about and lawyers know about in the community I've practiced in that can really be helpful to the government. So why not use them?
Mr. Barron, NARA has sometimes been unable to keep up with the pace necessary to digitize records in a timely way, and certainly the pandemic has exacerbated this problem. The agency has struggled to reopen research rooms all across the country and has amassed considerable backlogs of requests as a result of that. One particularly glaring example that I've noticed is the backlog of requests for veterans records from the National Personnel Records Center. My question to you, sir, is from your perspective, what is the primary reason behind these extensive backlogs and delays?
Well, I can tell you that I'm not at NARA anymore, and so I can't speak for them. But my understanding is that this is, as you say, a very big challenge, especially with veterans records, because of what NARA has done, which is to follow CDC guidelines on COVID. They've essentially not been able to get to the backlog, and that's unfortunate. I do have good news about researchers and research rooms that I heard archivist David Ferriero say just last week that NARA is essentially giving limited appointments to researchers to come in to do their research. And hopefully that will expand to both on a larger scale for research rooms to be open and for citizens to be able to use NARA. We all want that. So I hear you. I understand that it's a large problem, but I think NARA is working on it.
Ms. Weismann, current law does not set any requirements for the transfer of presidential records to NARA at the end of the administration beyond making NARA responsible for the records at the end of the president's term. So my question for you, does this lack of requirement around the transfer of presidential records to NARA create some real problems for both preservation and access?
Absolutely, and I think recent events really highlight this. From public reporting, I can identify at least two problems that occurred at the end of the Trump presidency. First, according to public reports, because the president refused to accept the results of the election, he delayed implementing the transfer of his records to NARA. And this is not a job that can be kept to the last minute. And I think, in fact, what this committee should consider legislatively is mandating that at the beginning of an administration, the White House work with the archivist to develop an accession plan with specific timeframes and goalposts in place and that the archivist be charged with monitoring that the White House's compliance with such a plan, and that it advise Congress when there are problems. The second very well-documented or well-reported on problem at the end of the Trump presidency was the fact that the president took with him, we now know, at least 15 boxes of presidential records, some classified at the highest levels. Now, because of the volume of presidential material that an individual president leaves behind, it's my understanding that quite commonly a lot of presidential records remain at the White House, even though the president has left, but they're still considered to be under the legal custody and control of the archivists. I think, again, through legislation, Congress could make it clear that no record that is under the legal custody and control of the archivists can leave the White House unless it has the express approval of the archivists. So those are two problems that we've just recently experienced and two proposed fixes that I offer.
Thank you, Ms. Weismann. Well, I'd like to thank Ranking Member Portman for holding this hearing with me here today, and I'd certainly like to thank each of our witnesses for joining us today in this important discussion and for providing your expert insights as to how we improve federal records management. The preservation of presidential and federal records is critical to preserving transparency, ensuring the federal government is working efficiently and effectively for the American people, and protecting our nation's historical record as well. I think as we heard from today's panel, the laws and the systems we count on to preserve these important documents are incredibly outdated, and Congress needs to take action not only to strengthen the records preservation process, but to also ensure that Americans get timely and appropriate access to these important resources. As I mentioned in my opening comments, I'm continuing to work on legislation that will modernize our record-keeping practices, strengthen enforcement of our records laws, and bring the law up to date with the emerging technologies that we see on the horizon. While NARA and the entire federal government have faced some serious challenges due to the lack of resources and accessibility, I certainly remain confident that we can address these challenges and increase transparency for every American. And again, thank you to our witnesses for helping us walk down that very important road to accomplish these ends. And with that, the record for this hearing will remain open for 15 days until 5 p.m. on March 30th of 2022 for the submission of statements and questions for the record. This hearing is now adjourned.